Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Hi there, and welcome again to Ask a Lawyer here on CP24. I'm John Scholes. I'm just the host. I don't do all the heavy lifting. That would be our employment lawyer, Chris Justice from EmploymentLawyer.ca, joining us here momentarily. I'll tell you right off the top how you reach Chris and the team anytime we're not doing this half-hour show. 1-888-861-4555. Ask at EmploymentLawyer.ca or simply EmploymentLawyer.ca. That's the website you can go to anytime. All kinds of stuff to get through on the show today. We're going to make us smarter over the next 30 minutes. You are going to learn a lot about your employment rights, your workplace rights, shatter some myths along the way. And our main topic, 5 rights that employees often forget about when it comes to their work life. We'll get to that here in just a bit. And maybe a couple of phone calls from our live radio shows. By the way, across the country, Chris and myself and the other lawyers in the firm host a bunch of those. Pretty much coast to coast, almost. We're getting there, and you can reach out anytime. In fact, locally here in the GTA, News Talk 1010, Sundays at 1 p.m. You'll catch us doing our thing for an hour and a chance to catch that show. But we'll get to all that in just a moment. Chris, welcome, pal. We always start off with the week that was. What do you got cooking this week?
Yeah, thanks for having me here, John.
Yeah, man.
I mean, always I answer questions every day about people with employment-related issues, whether it's going into a working relationship, during their tenure, or perhaps on their way out. And so it's very important that we understand just how much employment rights and employment law affect us on a daily basis, and to make sure that people are, of course, are aware of their rights, their entitlements, what options are available to them. So I had a case not too long ago come across my desk where I had an individual. He was a senior manager. He had been with the company for about a year, 60s. He was making a good amount of money. And he was let go after that year. And apparently he was let go for just cause based on some performance issues. Now, that always rings a bit of an alarm bell to me. Just cause, very high burden, but very high bar to meet for an employer because it's known as the capital punishment of the employment law world. So anytime someone alleges just cause, I always try to probe a bit deeper just to find out exactly what the issue is. And in this guy's case, about 2 months before the termination, he was brought in, had a discussion with the employer about some performance concerns. He actually disagreed, but nonetheless, 2 months later, they said to him, you know what, we haven't seen so much improvement from you. We're letting you go for alleged cause. And I told him as soon as he started to talk to me about it that there was no way there was cause in this case. It's very hard, as I say, for employers to meet the just cause bar. A just cause is essentially when someone has committed serious misconduct or a number of incidents of misconduct. And in performance-related issues, the employee almost has to go out of their way to be a bad employee, essentially. Yeah. So I knew right away it wasn't cause. We then started to talk about what he was owed, because he said to me, Chris, you know, I've been there for a year. Even if I am owed cause, what am I looking at in terms of severance? It's probably only a week or two. To which I said, well, no, hold up. You're in your 60s. You're a senior manager there. Even though you're there for a very short period of time, your severance entitlements are close to 4 to 6 months, not just a week or two. And a lot of people have a misconception where they think, oh, I haven't been somewhere for that long, I'm probably not that owed that much. But actually, they're owed disproportionately larger packages than some even long-term service employees. So I thought it was a good example of a case where you're met with the allegation of just cause. Very rare do employers actually have the merit behind that just cause allegation, and you are owed severance. But not only that, short-term service employees are looking at a lot more severance in those cases than they even believe they're entitled to.
As mentioned off the top, EmploymentLawyer.ca is our website. There you can find a radio station somewhere in your market you can listen to. Not only that, you can participate and call into the radio show as well. Possibly one of your calls will make it onto this show, and we'll talk about it, which is what we're going to do right now with our first phone call of the show, right here.
Was a manager for 21 years at a place. I had some health issues, and my doctor advised me to take some stress leave. After almost 8 months, the owner of the business said that I was no longer required to come back, and I got walk-in papers. I got 8 weeks severance, but I was there for 21 years,
wow,
managing 2 different businesses. And I'm just wondering, in that situation, is there any recourse?
Yeah, so in this case, there's two main things that pop out to me. Number one, why did the employer let that person go? Was it because they were on that stress leave, that they needed time off, and the employer simply said, I don't want to wait any longer, I've got someone else to fill your job? Because if even 1% of the reason why this individual was let go had to do with the stress leave, that is a violation of human rights, that's illegal, and the employer is not only now exposed to having to pay that person's severance, but also additional damages in the form of human rights and bad faith conduct damages. So that was one thing for sure. Now, the other thing that popped out to me was the 8 weeks. Given 8 weeks of severance, being there for 21 years, 8 weeks could easily be his bare minimum entitlement under legislation. And a lot of people incorrectly assume that what the Employment Standards Act, for example, says I get is what I get. But it's really just the bare minimum. It's not your full severance entitlements. And for this gentleman in particular, he's looking at close to 2 years of severance based on the amount of service he has with the company. So this is unfortunately a situation I see a lot of in my time in terms of employers just not wanting to wait around when in fact they could be obligated to accommodate someone's leave, not just for weeks, not just for months, but for years. So 8 months is by no means the longest someone can be off, and it really does depend on the scenario. But in this case, it seems like the employer is in a bit of hot water on two different fronts.
All right, we'll take a short break, guys. Coming up here, 5 rights often overlooked by employees. We'll dive into that after the break. In the meantime, here's that number again. Keep it 1-888-861-4555 and email ask@employmentlawyer.ca. We'll continue. Lots more Ask a Lawyer here on CP24. Stick around.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer here on CP24. Thank you so much for sticking around through the break. There's always a main topic in the show. This is the part where you learn a whole lot. And this week it is 5 rights often overlooked by employees. Chris Justice is here, courtesy of EmploymentLawyer.ca. You can reach out to Chris anytime, 1-888-861-4555 and ask@EmploymentLawyer.ca. Chris, number 1, this is your time, pal. The first one is this: the right to full severance pay when you lose your job. Don't forget about that, right?
Absolutely, absolutely. You know, a lot of people, again, incorrectly assume that if they lose their job, they might be looking at 1 or 2 weeks for every year they worked, and that's it. When in fact, the reality most oftentimes is you're looking at probably closer to 1 to 2 months for every year you've worked, not just 1 to 2 weeks. And that's going to be based on a number of main factors, including someone's age at the time they're let go, the position they actually held at the time of termination, as well as the length of service and availability of similar employment now that they've lost their job. But factoring in all of those different things, as an employee, depending on your circumstances, you can be entitled to upwards of 2 years of severance. So it's certainly a far cry from 1 or 2 weeks per year. Now, the other thing I just want to mention has to do with the Ministry of Labor. A lot of people come to me and they say, I've filed a complaint with the Ministry of Labor, or I'm planning on filing a complaint with the Ministry of Labor to seek my severance. That's a bad idea. The ministry can only get you your bare minimum entitlements, and if you commence something like that, it's going to be very difficult, if not impossible, for you to go back and try and get just more than your bare minimum. So if you're in that situation, you want to give us a call, get legal advice before commencing any kind of complaint with the ministry.
The second right often overlooked by employees, and I'm surprised we still have to actually keep mentioning this one, but it's out there in the workplace. That is the right to a workplace free of harassment. Chris, what do you think?
Yeah, it seems pretty standard that this should be the case, but unfortunately there are far too many situations where employers effectively condone an environment of harassment. You know, there's an obligation on all employers, doesn't have to be written, it's implied, it's in every contract regardless, to keep the workplace free of harassment and safe from any toxicity. And so if they're given a complaint, if the employer is given a complaint by the company about a harassment situation, about a toxic work environment, the employer needs to act swiftly. They need to find out, they need to investigate, because if not, if they brush it under the rug, if they take way too long in investigating, they're going to be seen themselves as having condoned an environment like that, and not only expose themselves to a potential constructive dismissal whereby the employee can essentially leave and get severance, but also be exposed to the possibility of a failure to investigate the issue itself, and then open up a whole can of worms in terms of additional damages.
We are talking about 5 rights often overlooked by employees in the workplace. Number 3 is this, the right to the same job after you return after a parental leave, right?
Yeah, so whether you're taking a maternity leave, whether you're taking a paternity leave, your employer is obligated to keep your job open or a job very similar to your job open while you're on that leave, so that if you come back, you're supposed to be coming back to the job that you had. And sometimes, again, unfortunately, employers either give that job away or they say to somebody they've eliminated that job, and then the question becomes, but for me taking that leave, would I have even been in this situation? So going back to the stress leave example earlier, the employer is now on the hook potentially not only for the severance payout, but also for human rights damages for failing to accommodate that person's leave, whether it's paternity or maternity.
Right, number 4, and this one is a big one indeed. That's the right to refuse to sign a new employment contract with a current employer, right?
Yeah, this is a pretty big red flag. You know, someone's been working at a company for a very long time and they get given a contract and they think, you know what, just some formality, I'm going to sign it, no really issue. And then they find out there's all this fine print in there, perhaps something that limits the rights on termination. And now they're in a different situation altogether. So if you're someone in that position where you've been given a contract, first of all, get legal advice before signing it 100%. But also you need to understand that in order for that contract to even be enforceable to begin with, if it's going to add certain restrictions onto your plate, the employer has to give you some consideration. They have to give you, say, a bonus or a payment of some sort. It can't just be going one way. So consideration has to flow both ways. But again, you want to give a lawyer a call, first of all, before you consider signing anything like that.
We'll get to one last one here. Chris, we're talking about rights often overlooked by employees. This one as well, the right to be accommodated at work if you've had a disability or some sort of illness, yeah?
Yeah, so we've talked about stress leaves, maternity leaves, and the obligation to kind of keep those positions available. But in terms of somebody who has experienced a disability but is able to return to the workplace, provided they've got the medical support from their doctors, that may speak to limitations, restrictions, maybe it's lower hours, maybe it's less duties for a certain period of time. Again, your employer is going to be obligated to accommodate those restrictions, even if they think it's an inconvenience or burden, and even if it costs them some money. They can't simply say, this is too much for us, we're not going to do it, unless they pass a test of undue hardship. So if you're in this situation and you're asking to come back to work with some restrictions, but your employer is giving you pushback, you may now be in a situation where you've been constructively dismissed, again, where there's been a failure to accommodate your disability and the employer, again, being open to not only having to pay you severance, but additional damages as far as human rights violations are concerned.
I want to mention that website again. Anytime you can go there, learn lots, reach out for contact information as well, EmploymentLawyer.ca. Also on the media page, you'll find a radio station in your market where you live, close by, where you can catch our weekly radio show. Here locally in the GTA, News Talk 1010, Sundays at 1 p.m. You'll catch us doing our show. We get a lot of phone calls on the shows. We'll play back number 2 from the radio show right now.
I work for a well-known security company, and I was in one position, and they involuntarily shifted me over to another position within the company at a lower rate of pay. I was told this position, it might be going union, might not be. If it goes union, the rate of pay will likely go higher. So I thought, okay, I'll wait it out. Kept asking every so often, any word on the pay going up again? No. And how long should somebody wait? Is there a time frame for that?
Yeah, so there's no definitive time frame, but people need to be cautious when they are being presented with changes to the terms of their employment. They can't accept those changes for too long. It's one thing to have a trial period to test it out in good faith, but if you accept changes or you're silent as to changes and weeks and months go by, you're going to be seen as having effectively condoned those changes, and it's going to be next to impossible to go back to the old terms of your employment. Your terms will effectively change. So it's definitely a situation that you want to get legal advice on and act sooner rather than later, because anytime a company changes your terms of employment significantly, that's known as a constructive dismissal, which in the eyes of the law is essentially a termination and would open up the same rights that you would have in the event of a termination, which include your full severance.
A lot of great phone calls there. In fact, I think we can nab one more, but we're going to take a short break before that happens. I'll give you the number in the meantime to write it down. Punch it into your phone. You never know when you're going to need to call Chris and his team. 1-888-861-4555. Email is ask@employmentlawyer.ca. Stick around. More Ask a Lawyer is on the way. This is CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer here on CP24. Thank you so much for joining us this week. You can always reach out beyond the half hour. Encouraged to do so. That phone number again, 1-888-861-4555. You can email ask@employmentlawyer.ca or the website, just employmentlawyer.ca. To continue on from there, I want to get to one more phone call, as I mentioned, from our long-running radio shows across the country. We'll do that right now. Listen up.
My friend, he doesn't know much English, so he works here for 22 years, and company got slow, and they laid him off. This is about before Christmas. They laid him off. They promised they will call him back. They never call him back, and I just want to know what's his option.
Yeah, so basically, this is another situation where time is of the essence, because if you're laid off, you might think, I'm going to come back. But the longer you wait, the longer you're going to be seen again as having condoned something, this time the layoff. And, a lot of people have a misconception where they think that layoffs are something employers are generally allowed to do. The legislation says they can lay me off for a certain period of time, but what they need to understand is that there is no inherent right to lay somebody off, even if it's on a temporary basis, unless that's in your contract or there's been a history of layoffs. And that's another issue with accepting a layoff. If you accept a layoff, next time a layoff happens, you may not have the ability to object to it because you accepted a prior layoff. So this is a time of the essence type situation. A layoff is normally treated as a termination in the eyes of the law. So in this person's circumstances, being there for 22 years, if it's tantamount to a termination, then they're going to be looking at upwards of 2 years of severance potentially. And actually, if we can go to the Pocket Employment Lawyer board here on the screen, you can see right there the stats, the age, the job, the length of service. And basically, there you go, 24 months or 18 to 22 months, if not greater, in terms of severance entitlements. For those actually that are interested in determining what their severance entitlements might be, whether it's because you've been laid off, constructively dismissed, or actually terminated, feel free to check out our website, pocketemploymentlawyer.ca, and that's going to give you a breakdown exactly of what your entitlements are.
There's another way, of course, to reach out to Chris and his team. They do a ton of live streaming on Facebook and YouTube. You want to take part at stlawyers.ca is how you do that. I want to get a question that was recently brought about on the live stream, Chris. As I was put on a performance review plan, I disagreed with it, but they said that they would fire me if I didn't do it. I became so stressed that I had to take 3 months leave for anxiety. When I return, they'll put me back on the plan. What should I do?
So first of all, it's good that he disagreed or she disagreed with it.
Yep.
Number one, if you're being presented with a performance improvement plan and you object to that plan and you have some pushback in terms of what's being said about your performance, you need to make your voice heard. You need to record it in writing and you need to send it to your employer, because if you don't, then the employer is going to potentially use that as a way to let you go later on if they're looking at building a case against you. So it's good that this individual raised some concerns. I don't know if it was in writing, but writing is always important. Now, if as a result of being put on a performance improvement plan, you do experience stress and you need to take a leave of absence, that's completely fine. If you've got the backing of your doctors, of your treatment providers, again, your employer is going to be obligated to accommodate you while you're on that leave. And if they take any retaliatory action against you for whatever reason, then that's going to expose them to a lot more damage than otherwise would be the case. So that's what this person should do. They should get better, first of all, but they should just work with their doctors and work towards trying to come back. And then if there's any issues with the employer, obviously give a lawyer a call before having any significant communications. With that, we'll take a short pause. I think we got time for another email or so. We'll get to that after a short break. That number, going to hammer it to you once again, 1-888-861-4555. It is ask@employmentlawyer.ca. And any other time is simply employmentlawyer.ca. We'll get to that after a short break. Stand by.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer. A couple of minutes here to go. I'll tell you how to reach out after the show anytime to Chris and his team. The number 1-888-861-4555. Email is ask@employmentlawyer.ca. That's where we're going to go right now. Get to one more email here. Chris goes as follows. Says, when I was hired 7 years ago, I signed an agreement that said I was a contractor. No taxes are taken from my pay, and I work a fixed schedule. They're laying some staff off now and giving them 2 weeks' pay. Would I get the same amount if I was to be fired?
Yeah, it's a good question because it raises the idea of contractor versus employee. And a lot of people incorrectly assume that because their employer tells them you're a contractor, or because there's a contract that says you're a contractor, that automatically means you're a contractor. But the fact is that neither you nor your employer can determine what you are. It's ultimately the law that determines that. And it's going to come down to the relationship you have with that company. So generally speaking, the more control that your employer exerts over you, the more dependent you are, the more exclusive you are with that employer, the more likely you're going to be seen as an employee. And on the flip side, if you're more autonomous, can do what you want, set your own hours, have your own tools, etc., you're going to be likely more seen as a contractor. But in this person's case, the fact that they're paying their own taxes is not going to be enough to determine that they're a contractor. And in most of these scenarios, people are actually deemed to be an employee. So if that person's there for 7 years and they're an employee and their employer's only offering them 2 weeks, then that's going to be woefully inadequate. Their employer's going to owe them much more than that, probably closer to 10 to 12 months potentially, not just 2 weeks. But that is a common misconception that people need to realize. You are not a contractor because someone told you so. It's going to depend on the relationship that exists, and that requires exploring further.
And with that, we are just about done. By the way, if you want to find out if you really are a contractor or not, pocketemploymentlawyer.ca. That is the website you want to use. I want to thank you for tuning in this half hour. Chris can always be reached at 1-888-861-4555. Ask@employmentlawyer.ca, or the firm website, simply employmentlawyer.ca. And radio, as we mentioned, across the country. You'll want to tune in locally here in the GTA. That would be News Talk 1010. 1 p.m. on Sunday. Again, News Talk 1010, 1 p.m. on Sunday. And reach out anytime, and maybe your phone call will appear on a later show. Thank you so much for watching Ask a Lawyer here on CP24, and we'll catch you next time.